Hey everybody, Zach Wolf here with another great Top 5 Tuesday. This week on Top 5 Tuesday, it's the top 5 easiest ways to defeat a claim of fraudulent inducement. And it just so happens that I'm doing a webcast on this topic today here in beautiful Austin, Texas with Texas Bar CLE. So if you see this video in time, register for our webcast and check it out. And if you don't see the webcast, you can check out my blog posts on this topic at my blog, 5minutelaw.com. Okay, let's get to it. First of all, what is fraudulent inducement? That is the claim that someone fraudulently induced you to sign a contract. And it's a theory that people will often use in court to try to avoid the effect of a contract that is no longer favorable for them. The number 5 way to defeat a claim of fraudulent inducement is something called a merger clause. Now, this one's a little tricky because I put it number 5 because a merger clause actually is not a very good way to defeat a claim of fraudulent inducement. There was a Texas Supreme Court case called Italian Cowboy Partners where the court considered whether a merger clause barred a claim of fraud. What's a merger clause? Well, that's where the contract says something like, this contract replaces all prior agreements and understandings and representations by the parties regarding the subject matter of this contract. And in Italian Cowboy Partners, the court said that's not the same as something called a disclaimer of reliance, which we'll get to later. And so they said if it's just a merger clause, that's not enough to defeat the claim of fraud. The number 4 easiest way to defeat a claim of fraudulent inducement is when the misrepresentation at issue is a statement of an opinion, not a fact. One classic example of this is when people engage in something that the courts call puffery. Puffery is something like, hey, this used car, this is the greatest car, you're going to love it. Even if the person who tells you that knows it's not true, that's probably not going to form the basis for a viable fraud claim because that's puffery. It's a statement of the person's opinion, not a statement of fact. The number 3 way to defeat a claim of fraudulent inducement is to show that there was no duty to disclose. Now, that's not going to work when the representation at issue is an affirmative misrepresentation. Where it could work is where the claim is that there was a fraudulent omission. That's where the person you're entering into a contract with makes representations to you, but leaves out some important fact. That's an omission. The problem is if there is no duty to disclose, then that omission is not going to provide an adequate basis for a claim of fraudulent inducement. All right, number 2, now we're getting into the really good ones. The number 2 best way to defeat a claim of fraudulent inducement is a disclaimer of reliance, which I mentioned earlier. The Texas Supreme Court for a while now has said that a disclaimer of reliance, where the contract says that no one is relying on any representations other than what is in the contract, the Supreme Court has long said that a disclaimer like that is enforceable when it's in a settlement agreement. But more recently, the court expanded that rule and applied it even in a case where the parties were entering into a new business relationship and signed a contract. the disclaimer of Reliance may still be enforceable, especially where the parties to the contract are sophisticated or experienced businesses, and especially when they're represented by lawyers. All right, now the number one easiest way to defeat a claim of fraudulent inducement is justifiable reliance, or rather the argument that there was no justifiable reliance. This has really been the emphasis of the Texas Supreme Court in some recent cases where they've said that no reasonable, experienced business person would justifiably rely on misrepresentations that conflict with statements in the contract. That's going to be the easiest way to defeat a claim of fraudulent inducement, and you now have several Texas Supreme Court cases you can cite that will support you. So those are my top 5 ways to defeat fraudulent inducement. If you'd like to know more, check out our webcast, which I think will be archived for later viewing, or check out my blog posts. And hey, thanks for watching.